That is correct, but I know most...
Because you give us a letter to tell us that you are going to retain shares worth 200,000. We just proceed with children taxes.
But that's what
If
it's
there's something peculiar, then we take it.
maybe the hearing can be there.
Now, since I let her take it.
How many people are you on that?
We will be charging the accused person, the respondent, on Monday, business week at 5, on Tuesday, 10, if it's convenient to the defense, instead of waiting to the 19th.
Your Honor, we humbly believe that the court has made him considered.
Kutumia zile SIM card ambazo zinatumika kwa simu, hizo ni mambo ambayo yanaweza yakafanyika hata wewe ukiwa nje. Tunaelezewa na sheria ya kwamba kama hakuna sababu nzuri ni ya 5 nusu milioni, na ya 3 ilikuwa nimeelezea ya kwamba itabidi iwe unajipeleka pale kwa mchukuzi wa kesi kila baada ya siku 2. Ikifika saa 9 ikupate wewe uko pale kwa DCI, na pia ni sawa kama wanaendelea Jumatatu uje usomewe mashtaka, manake wamekamilisha uchunguzi.
Tunokora na pera.
It is important to balance the prosecution and the respondent's person's rights. It is within public spheres at this juncture on the notoriety of bringing suspects to court without completion of investigations, unjustifiable and unlawful use of arrest as a starting point to commence investigation was to the judge a violation of fundamental rights to human dignity and liberty entrenched in the Constitution. It is also a driver of many applications before our courts for further detentions to gather evidence against suspects. There is no evidence that the release of the respondent would impede their investigations into the mobile phones and SIM cards of the respondent, which are already in possession of the investigating officer. The investigating officer stated that the respondent may tamper with evidence, and it was for the respondent's own safety that he be detained. But there is no evidence presented to the effect that the respondent has interfered with investigations or witnesses. I find I am grounded on the fact that no compelling reasons have been given to warrant the respondent to be detained or denied bond pending the conclusion of investigations. In granting of bail bond, I have considered the nature of the intended charge the respondent may face, including the possibility of the respondent being a flight risk, among others. Consequently, this court finds no merit in the present application by the prosecution, and I proceed to dismiss the same. Pending the conclusion of the investigations, may be released on a bond of 500,000 with one surety of similar amount, or a cash bail of 300,000. And in addition, he should execute a personal recognizance of 500,000. He is finally to report to the investigating officer every 2 days at 3 p.m. until his case is mentioned in court. And I say on 19th, because the other miscellaneous files are due for mention on 19th. That is when we'll know whether the police found any evidence to warrant the accused to take plea or not.
We welcome the decision. The decision and ruling has nourished and flourished our jurisprudence. The ruling has been delivered, and I said that ruling has enhanced the rule of law. It should be noted that even the President of the Republic of Kenya has been categorical and committal that police officers must be bound by the rule of law. And now we also happy that the courts, being the custodian of the rule of law, has nourished and upheld the constitutional principles. Going forward, the police officers should know that it is not business as usual. They are bound to follow the rule of law and the principles set by the Constitution, the relevant statutes and the regulations.
You have all seen that the application that was made by the state to continue detaining our client was dismissed this morning. And this is a win for the justice, it is a win for the law and the Constitution, because clearly there are no reasons to continue the detention of our client. And we just want to emphasize that going forward, the jurisprudence of this country has been built, and we know that situations like this might happen in future. But we are also confident that if such situations happen, then we have this ruling for the sake of posterity. Of course, the accused is yet to be charged formally in court, but the allegations of cybercrime are the same, have not been substantiated, so they remain to be mere allegations. The accused person is going to be charged formally, probably on Monday or Tuesday, but as it is now, we are processing the bail and bond so that he can be released as per the court's directions.
Hii picha wote tunapiga.
Ukikula ulikuwa wapi? Huko unajua kuna picha? Eh,